3167 with the USC case number 26G2020002806. The complainant is Jose Garcia Joven. The respondent is the Milwaukee Board of School Directors on Administrative Law Judge Stephanie Brown. It is Monday, March 27, 2023, approximately 9:25 a.m. We're here for the fourth day of hearing on the merits of the complaint based on a complaint filed between the parties. I know, I guess I should just have the parties state their appearances first before we go ahead and get started. Who is appearing here on behalf of the complainant today?
Ben Hitchcock Cross of Cross Law Firm, appearing on behalf of the complainant.
All right, and for the respondent?
Chris Riordan and Ryan Milwaukee presenting over on behalf of the respondent.
All right, and I know Attorney Hitchcock Cross, you had sent an email earlier today. Your client, Dr. Garcia Joven, is not here today. You said that he has, you've been diagnosed with COVID, is that correct?
Right. Tested, I guess is a fair way to put it.
Okay.
Yeah.
And so, are you prepared then to continue on with your case? Because when we concluded the third day of hearing, you were still in the complainant's case in chief. Do you have any other witnesses?
Right. So to be clear, he's the only witness. The complainant's the only witness left for us to go.
All right.
So I think really we need to figure out what we want to do, given that's the case. He's flexible. I don't think he's prepared to testify today. I would like to talk to him. Again, happy to give you an update as soon as I have that. But
sure.
I'm clear on that as far as this morning. But otherwise, we're flexible and can do whatever needs to happen here.
All right. Do you have any response or thoughts on that?
I do. It is my understanding from Attorney Hitchcock Cross's email, Dr. Garcia Joven was diagnosed with COVID. Was it yesterday? When was he diagnosed with COVID?
I couldn't say that, but I could say that I learned of it yesterday.
And that's the reason why I can't appear here. Actually, we've done some checking, and my understanding is that Dr. Garcia Joven has been on vacation since the 23rd in Colombia. And that's why I can't appear. So we would actually move to dismiss the case based on the fact that he is to appear here today, has been notified of this hearing since February 22nd, 2023. And if he's not going to appear, as he was warned in the notice of continued hearing, that if he failed to appear for the scheduled hearing or responded to the Wisconsin Equal Rights Division within 30 days of the date of this letter, the EEOC may dismiss your charge. So unless they're telling us that he's in the country and he can't appear, I think the tribunal should dismiss this matter.
What do you want to say in response to that, Attorney Cross?
Sure. I think we don't. Where he is, or I haven't, my client has not confided his travel plans in me, so I'm not able to speak on that. I do have a test from a testing facility that I believe is in Colombia, and that would not surprise me that that's the location that he got tested in. Other than that, I can say that he's not available here today because of that diagnosis or test, and more than that I can't say. So if they've got some, they're really arguing bad faith here. So he's got some bald-faced assertion about that basically my client is refusing to appear here, and that is unsupported by any evidence, first of all, but also if they can prove that claim, I'd like to see it, and then I can respond to that. Because otherwise they haven't said any bad faith. They just said that he isn't here. We've explained to you why he's here, or why he's not here, and I think that part in itself is clear.
I'm going to respond.
Sure.
First of all, Attorney Hitchcock Cross just confirmed that the client is in Colombia. Attorney Adrian Madeline had checked with his supervisor, who indicated he's been out of the country since the 23rd. If in fact he was going to participate in this hearing, we should be notified so we could set up a WebEx or something to prepare for. doing this in bad faith. We actually brought it to the tribunal's attention. Attorney Hitchcock did not bring it to your attention that this client was out of the country and could not appear here. It says in the continuation, notice of continuation here on the merits of the complaint on the second page, that if you fail, and this is a letter to Dr. Garcia Joven dated February 21st, 2023, if you fail to appear for the scheduled hearing or respond to the Wisconsin Equal Rights Division within 30 days from the date of this letter, the EEOC may dismiss your charge. Now, the fact that he didn't tell us he was out of the country and allow us to prepare for a WebEx hearing, I think is really significant. They were trying to hide the fact that he was out of the country, or they didn't know, or Dr. Garcia Joven didn't tell anybody that he left. Whatever the circumstances are, he is not here. He is not appearing here. He has not set a WebEx hearing to talk to us about this. We have no confirmation about the diagnosis of COVID. Attorney Cross indicates that he has some kind of diagnosis that he was sent from a clinic in Columbia. We don't have that here today. If he was going to provide us with that, he should have today. He did not. I think either he rests his case today or the tribunal should dismiss it.
Do you have anything else?
Oh, I sure do. I sure do. And I appreciate this opportunity. So, once again, we've got accusations of bad faith here from Mr. Riordan. He is testifying, which is fine. If he wants to get somebody up here to, maybe Mr. Maloney can examine Mr. Riordan here and we can get Mr. Riordan's evidence up on the record if that's what he wants to do. But we just need to back up a second here and look at the larger pattern that involves Mr. Riordan and his outright contempt for employees. It mirrors his client's outright contempt for employees. For him to say, I mean, it's just paternal here. It's just preposterous. If they, he's trying to say that Mr. Garcia Joven can't go out of the country on vacation, because that's apparently what people can't do. Apparently Mr. Riordan is the one who gets to decide where Mr. Garcia Joven goes. Apparently Mr. Riordan's the one who gets to decide whether Mr. Garcia Joven gets sick or not. Apparently Mr. Riordan is in charge of the coronavirus and knows how and if it is going to affect somebody. Apparently Mr. Riordan, and you know, also he's trying to give us here information on, they of course use their employees and they use their employment power to go spy on Mr. Garcia Joven, and now again he's alleging facts. They have no idea what Mr. Garcia Joven's travel plans are. They have not produced any evidence to say that they know what Mr. Garcia Joven's plans are. And you know, it brings me back just to Friday here. We had a deposition in Dr. Ford's case on Friday. And in that deposition,
I'm sorry, I'm going to object.
You can object all you want, sir, but you just wait till I'm done finished. Thank you.
Let him continue this call.
So in this deposition, I left this room for about 2 minutes. In that time, Mr. Riordan decides that he's going to have conversations with Debbie Keither about Debbie Keither's removal to federal court. In fact, he called her a coward. He told her that he can't wait to get her on the witness stand to depose her for 7 hours. He made other comments directly related to his case against Dr. Keither. This is MPS, of course. He also then, you know, I thought rather foolishly spoke to Dr. Ford, I think not really understanding the power that woman has, and that it would not, I mean, if he was threatening her, he would have a significant problem. This again goes to Mr. Riordan's continual underestimation of employees, his vilification of employees, his accusations of bad faith against other people. He came in there, I think, and accused me, this is on Friday, of misconduct and about 10 times. he said that we had acted in ethics about 10 times, which, brings me back to a letter that the tribunal wrote out in this case here about the ethics of myself and let's say, the propinquity of having my representation of Dr. Angela Ford in regards to a deposition. In this case, well, somehow an independent body got hold of that letter, and it took them about less than 24 hours to figure out exactly what Wisconsin law is, which is what we had explained to you, that namely, an employee, a coworker, cannot be adverse to another coworker under the Wisconsin Fair Employment Act. So we all figured that out pretty quickly. I think, again, less than 24 hours. It might have been substantially less. I understand people have to go to work. People aren't working all the time. Sometimes they sleep. So that may have accounted for how long that took to respond on that issue. I think we were all very clear on the ethics of that. And I think that independent body is also very clear how, in fact, when Dr. Angela Ford had filed a complaint against Milwaukee Public Schools in this case, for them to contact her in any fashion, which is exactly what's taken place here. We had testimony from Matt Chasen on Friday, giving us a direct through line from Dr. Garcia Joven, Dr. Keither, Dr. Ford, and others, and Dr. Saffold, and retaliation from Dr. Holliday. So I know that there's been a concerted effort here by the tribunal and others to sort of keep those issues separate. I know that the tribunal told us last time that that was common sense, and that moreover, that even though Dr. Holliday, the tribunal admitted that Dr. Holliday was relevant to this case here, we were still precluded from bringing Dr. Holliday there. Of course, now we have evidence that all those things are connected, despite the best efforts of MPS withholding that evidence, and again, trying to keep it from us on the grounds, first of privilege, then saying that Matt Chasen was that they represented Matt Chasen, and then, of course, in this case, we had a attorney by the name of Savion Grinnell of Bulow Vetter represent Mr. Chasen in this case, although and you, of course, responded to that. Mr. Chasen had no idea that he was being represented by Savion Grinnell, and I said so under oath. We brought that to your attention, but again, here we are. So when we're going here, I think that this is, again, more projection from Mr. Riordan and Milwaukee Public Schools. Again, I'd like to repeat here how in this case we tried to serve process on Dr. Holliday, and Dr. Holliday, Milwaukee Public Schools employee, and what we say is a bad actor in this case, although the tribunal has refused to allow us a priori to even discuss this matter, assaulted our process server in that context there. And again, we had testimony on this last time that we were here. Again, MPS there is using its employment power and physical power to assault those in its custody and to, generally act in bad faith. So this, again, the standard here that they're trying to allege reaches something of bad faith. Now, so far, he's made a bald-faced assertion where my client is, and that he's out of the country not because he's let's say victim of a illness, but he's there on purpose, trying to thwart the state of Wisconsin's order to him. Now he knows he doesn't have any evidence of the kind, and he continues to repeat it. This again is the same sort of projection that we've seen from Mr. Riordan, again, on as recently as Friday, accusing Dr. Ford and myself and others of misconduct. While again, I left that room for 2 minutes, Judge. 2 minutes. And here, it wasn't even this attorney over here, who's accusing me and my client of bad faith, goes over to Dr. Keither and says he can't wait to get her under testimony and depose her for 7 hours because she's a coward. So, you know, that's the kind of behavior that MPS and its representatives do. I mean, we know that. It's the kind of behavior assaulting Dr. Keither when we're trying to serve process in this case is the kind of behavior that we have expected and grown to hear from MPS. Bad faith, in other words. They say one thing, both to the tribunal and under oath, I think, here, and he makes representations. You know, I just want to bring us back to Friday because he didn't dare say any of those things in front of me. He didn't dare do that. He didn't. He waited till I left the room for not even 2 minutes. He couldn't wait till he had his opportunity to go and talk to a represented party about facts related directly to this case. He couldn't wait. Neither could Savion Grinnell. He didn't deny that he made those statements. He just said, hey, the case in the Equal Rights Division is withdrawn. I guess he doesn't know that there's a parallel case within the EEOC. I guess he didn't figure that out. So he admits that he makes those statements. We got it on the recording. It's going up, I think, in about an hour or so. And, you know, he admits that he makes these statements, but claims, hey, there's no claim. So we can say whatever we want to her. So, you know, this is what happens when there are no consequences for assaulting Debbie Keither when the process server, when we try to serve Dr. Holliday. There are no consequences when there's a letter out to us saying, hey, this is unethical here. You representing Dr. Ford and you representing Dr. Garcia Joven at the same time. And, you know, they, of course, made hay of all that, and we had to spend time and time answering all of that. You know, but, of course, when an independent body reviewed that, although we put that to you, Judge, we put those exact facts to you. We asked you to recuse yourself on those grounds. You didn't even respond to that. But, again, when an independent body looked at that, they were able to determine clearly what Wisconsin Fair Employment Act says and what an adverse party actually is. So again, I think that it's clear that here we are, the employee once again is the victim, both of bullying by this employer, by their specific special counsel, because the city attorney apparently couldn't hack it in this case, and also from the tribunal here, which, as we were clear, not only went back and forth on whether Holliday was relevant, not only put on the record and put in Dr. Ford. Let's recall, Judge, that letter got sent to Dr. Ford's case, okay? And it's also, right, Dr. Ford now has a probable cause, and we now have discovery on that, and we now, through that discovery, discovered that, oh, it's directly linked to Dr. Garcia Joven's case. Why? Who said that? Matt Chasen, because we got him under oath. Maybe that's why he didn't like it, and maybe that's why he had to make those comments. Mr. Riordan had to make those comments to Dr. Keither. I don't know, Judge. But he sure had a long leash to do it. And they sure got away with a lot of bad faith. And for them to sit here and accuse us of bad faith with no evidence, and to say that my client is purposely out of the country for the purpose of, not being here today. I guess I'm thinking here of just other examples of bad faith in this case here, and I guess I'm afraid that we might be here for another 20, 30 minutes if I were to go through them all, because we've pointed them out time and time again, but the trend here has been to not take any action here. I didn't notice any letter being put in their file, in the Ford file, for example, about their misconduct. I didn't see any letter. Oh, this only went one way, and that whole point was to separate these Dr. Garcia Joven, an employee, Dr. Keither, an employee, and Dr. Ford, an employee, from getting their redress against this employer in front of a fair tribunal. That's what we're entitled to, but that's not what's happening. And to hear these Milwaukee Public School representatives accuse my client of bad faith with no evidence is beyond rich. It's, I'm going to go to say it's disgusting. And in closing, Judge, we had, and it's a great clip, I think you should see it, we had a great discussion on Miss Pigglewiggle on Friday. And I think my daughter, on seeing that clip, because not everybody in this room apparently has had the advantage of Miss Pigglewiggle, and she thought that people who hadn't had that advantage might need a hug because they had not had an opportunity to grow. And I think that's, I'm inviting everybody here to grow and to learn a little bit here from, you know, you're accusing somebody of bad faith, and it's not covering up your own naked bad faith very convincingly. Thank you.
I do. One, I dispute most of what the Hitchcock process said here today. I don't want to get into the specifics because I want to get back to the point that we're here for, and that is the continuation of this hearing. As we have indicated, and as Attorney Cross has substantiated, Dr. Garcia Joven is in Columbia. In fact, Attorney Hitchcock Cross has indicated that he has a copy of a COVID positive test from the Columbia clinic, but we have not seen it. As we have indicated, it appears that Dr. Garcia Joven has been in Columbia since the 23rd, and there has been no attempt to set up a WebEx hearing or appearance form. I think that's really telling. The fact of the matter is they didn't intend to have him appear today. Otherwise, they would have scheduled or notified us of his absence and would have scheduled the WebEx hearing. That has not been done. This has been noticed since February. And as I indicated, along with the continuation, the notice of continuation of hearing indicates that to Dr. Garcia Joven, if you fail to appear for the scheduled hearing or respond to the Wisconsin Equal Rights Division within 30 days from the date of this letter, the EEOC may dismiss your charge. And it's important to note, whether he's in or out of the country, he made no attempt to be available for this hearing. He could have by WebEx. In fact, you sent out a notice today, Judge, indicating that he could appear by WebEx. It could have been that simple if they would have notified us earlier, so we could have prepared for it, but they did not. I think the remedies are, one, they either rest their case or the case be dismissed.
Yeah, so we almost invite you to dismiss this case because Dr. Garcia Joven has contracted the COVID virus. That would be really just about all that would need to be said on that issue here.
I asked that he produce the picture.
Excuse me, sir. It's just, again, outrageous that you continue to interrupt. It's, you know, it's this kind of disrespect here that Mr. Riordan is displaying that is exactly the kind of behavior that we had on Friday and exactly the kind of behavior that, you know, could benefit from a little insight from Ms. Pigglewiggle. I also want to say that, again, everything is just hogwash. And we invite you to accept this hogwash here that that he had some responsibility to know when he was going to contract COVID from when we had the notice sent out. That he has some responsibility to appear here today despite the fact that he is suffering from the COVID virus. That he has some responsibility to appear here today and give testimony here despite the fact that he's sick. I mean, this is a disease that people die from. This is a disease that stopped the entire planet for about 10 months. You know, and Mr. Riordan's personal views on the virus or how serious it is, or because he's told us all about it, Judge, or let's say methods of protecting oneself from the virus aside, I think that the science here, for lack of a better word, and the custom and what we actually do here in the state of Wisconsin is that when somebody has a life-threatening disease, we don't make them testify. But if you feel like you have that, want to go make somebody testify when they're suffering from a life-threatening disease, I guess we can't stop you.
I just want to ask you a few questions. So, setting aside that Dr. Garcia Joven is tested positive for COVID, has he been in Columbia since, when you say the 23rd, is that March 23rd?
I'm sure he's been in Columbia since then, I'm sure.
Was it his intention to appear here today then?
That's my understanding, yeah.
And he can't appear virtually?
He can't, as we've discussed, he is not in a state to testify today. Whether he can testify tomorrow, I've said that I would talk to him at my nearest opportunity and update you on that. But as far as I know, it's not possible today. I've got that confirmation this morning.
Is there anything else you want to add?
No.
Do you have witnesses to put on today?
Depending on, it was all dependent on what Dr. Garcia Joven was going to testify to. So, no. I mean, I'm not going to put witnesses on before they finish their case.
I also want to add, Judge, remember how we subpoenaed Dr. Holliday. And Dr. Holliday, there was no sanction for him not appearing. I just want to be clear that we subpoenaed Superintendent Posley. And we understood from you that you had no authority to enforce those subpoenas whatsoever.
No, but the complainant is expected to appear at a hearing. I'm not going to dismiss the complaint because I think you can act as his representative and clearly you're here today.
Mm-hmm.
I'm just trying to figure out how we can go on with this hearing. I guess I'm a little concerned if Dr. Garcia Joven was planning on being out of the country, how he was planning on appearing here, knowing that the hearing, I mean, he would have received a hearing notice a few days after February 21st, 2020.
Don't you think they have airplane service from Columbia to the United States, Judge?
I'm sure they do, but I'm just a little bit concerned if you knew he was going to be out of the country, why did you first of all agree to these dates as the hearing dates, and secondly, when you knew that he wasn't going to be back in time for the hearing, let us know ahead of time.
So I don't know how international travel works in your experience, but in my experience, when you test for COVID, they don't allow you to enter an airplane.
Right, and you said he tested positive yesterday.
I didn't say that. I did not say that. I said that I learned of it yesterday.
But still, I think you have to, my understanding of international travel is you're required to take COVID tests so many days in advance before you leave the country. So if he just found out yesterday, or you found out yesterday, that would suggest that he was planning on flying back to be here in time for the hearing today.
How so?
Because I think you have to take a test days in advance of you flying.
Okay, and so
you can take a test positive the day that your flight is intended to leave the country.
Okay, but so again, that would be a possible inference, Judge, if you had anything like evidence saying that he took the test yesterday. But you don't even have that, and you're already going to bad faith on that, just on that basis. I do have a copy of it.
Can you show it to us?
I absolutely can, but we're not at that point yet, because, excuse me, because again, here, without even that fact, there is an allegation by the tribunal that he's supposed to have been back here, and otherwise, that because I told you that I had a COVID test, which I found out yesterday, that means you took the test yesterday. There is no possible way to make those chain of inferences, and you should know that. And that's a big problem.
Well, I think the problem is on your end. You have the responsibility of making sure that your client appears. And I think if you're requesting some kind of postponement or continuance, you would have come here today prepared with all that information to tell me when you learned it, when everything was taken, so we could take that under advisement.
Well, again, You asked that question, I've said it 3 times now. I learned when he was, that he was ill yesterday. Okay, that's the 3rd time I'm gonna say, that's when I found this information out. But so, then I emailed Mr. Riordan, you have a copy of that email, and then I emailed you this morning per the discussion that we had to find out what we were gonna do today. Right, so that's the evidence that we have here. So to say again that I'm supposed to put some facts on the record, or rather, what we should have done based on those facts is evidence, I think, of bias.
Do you have anything else, though, to show that he was intending to appear here for today?
That's not how bad faith works, Judge. What we have is that he is unable to attend because he has contracted the coronavirus. That's what we have, Judge. We don't have to prove that he took some effort to try, after he contracted the coronavirus, that he was then going to try to come back here. What we have is evidence saying he's unable to do so because of the coronavirus.
And actually, I don't even have evidence of that.
Okay.
I just have your statement to me.
Right, and just as you have his statement over there. Right.
But I'm trying to decide what I should do with your case, because you still have not presented your complainant, and as I understand you, that's the only witness that you have to put forth yet.
Right.
So I'm trying to decide whether or not, because your client, your complainant is not here to testify, I should consider that you resting your case and let the respondent put on its case.
Why would you prejudice us because our client has contracted the coronavirus, Judge?
Because there's a suggestion that there is something else besides that.
Right, so there's an allegation of bad faith upon which you have no evidence, so your solution to do that is to conduct discovery on behalf of MPS to find out what my client's intentions were. That's outrageous, Judge.
Actually, it's not. Honestly, I've been doing this job for 9 years. This is the first time I've had a complainant not appear, not even for COVID or anything else, when there's a continued hearing. Honestly, if you knew yesterday that he was not going to be able to appear, I would have expected you to let me know yesterday, not at 7:59 or 7 something this morning, that he wasn't able to appear. That's when I first got your email.
Okay, well, you're a state worker, Judge. I'm not going to email you on Sunday.
You can. I mean, that's you won't look like you want to say something. Attorney Riordan.
I do. I apologize. Attorney Cross has indicated that Dr. Garcia has been out of the country since at least the 23rd. We have information that he was going to be out of the country through April 2023. So that would be past this year.
And how do you know that?
Avery met a lady that can check with his supervisor, and we found out that he had COVID.
Then let's get this evidence on the record, Judge. If you're going to rely on this, let's get it on that record.
Do you have someone that can testify to that?
Avery can.
I can testify. Sure. Why don't you come a little bit closer so we can hear you then? And I'll swear you in just so that we know that. Raise your right hand, do you solemnly, sincerely, and truly declare and affirm that the testimony you give is the truth, the truth, and nothing but the truth. And what is your name again?
Adria Madeline.
Could you spell that, please?
First name Adria, last name Maddaleni.
And what is your position?
I'm Chief Human Resources Officer.
And you've been in the room because we've been having this discussion. Attorney Riordan said that you have some information about Dr. Garcia Joven and a vacation that he has taken. I guess first of all, as the Chief Human Resources Officer for MPS, can you tell me some of your duties? I guess generally, how would you have come up with any kind of information relating to an employee's vacation?
Part of human resources, I oversee absences. Our system, our data management team enters absences, including vacation, sick leave, those types of FMLA leave, medical leave, leave, personal leaves. We oversee, administer those types of functions for the district. have the ability to whether it be reach out to a supervisor or look into our system, depending on how far back, to see if what someone's absence is coded in, like vacation, sick leave, or business, or any other type of leaves that we have.
And so in that, I guess first of all, did you look into the records to determine if Dr. Garcia had some absences?
Due to the timing of the absence being today, initial thought was that would have been an illness. So it wouldn't have been in our system yet coded if someone was ill. So I reached out to the chief academics officer who oversees curriculum instruction and asked if she was aware or if she could find out from Dr. Garcia Joven's supervisor whether Garcia Joven had called in sick today.
And who was the person that you spoke to? You said that you reached out initially to the chief academics officer. Who is that?
Jennifer Mims Howell.
Mims, you said?
Yes, MINS-HOWEL.
And then after you reached out to her, I think you mentioned someone else. Did you say that it was you or her that reached out then to Dr. Garcia Joven's supervisor?
I asked her to reach out to Garcia Joven's supervisor. She didn't know.
And do you know if she did that?
She responded back to
Objection, you said.
She responded back to me and said that Garcia Joven is out on vacation. He's been out the 23rd in our records through April 30th. Be out on vacation.
And we said the 23rd, that's the 23rd of March.
Correct.
Excuse me. Did you have any questions you wanted to ask her?
Sure. So you said you spoke to Jennifer Mims Howell, right?
I contacted her
Okay, how'd you contact her?
via text message.
Okay. And then who did she contact?
I do not.
You don't know who Dr. Garcia Joven's supervisor is?
I know who his supervisor is, but I don't know for sure if who Jennifer Mims Howell contacted.
So you don't know where this information came from, is that what you're saying?
I got it from Jennifer Mims Howell.
Sure, and but you don't know where she got it from.
I did not.
Okay, and so to be clear on the information that you have is that Dr. Garcia Joven forwarded, Garcia Joven's on vacation or what?
Correct.
Okay, and so when somebody's on vacation, do they have to report to you if they're ill?
No.
No, okay. So Dr. Garcia Joven would not have had to report to you today that he was ill, correct?
Correct.
Okay. And when an employee's on vacation, they inform you where their location is?
They do not have to.
Okay. Do you know where Dr. Garcia Joven is?
I personally do not know.
Okay. Do you know anybody who does? Okay. Do you know how Mr. Riordan got the impression that Dr. Garcia Joven was in Columbia?
Do you know how many
Well,
What do you mean, well?
it's the conversations that we had. Do I need to?
That's attorney-client privilege.
That's absolutely not attorney-client privilege.
So you, well, I guess, so you do not know that, well, let me try to see if I have a tickle in my throat. So if I'm understanding you correctly, you found out that it's your belief that Dr. Garcia Joven is in Columbia based on your communication with Attorney Riordan?
No. Through my communication with Jennifer Mims Howell.
How did Jennifer Mims Howell determined that Dr. Garcia Joven is in Columbia.
I don't know who she spoke to. She responded back that he needs vacation, been scheduled vacation March 23rd to take.
But she didn't say anything about where he was going to be at.
She said Columbia.
Okay. You can continue with your questioning.
Okay. So who did you tell what Jennifer Mintal told you?
Again, I think we're getting to attorney-client privilege.
Did you talk to Attorney Riordan about that then? Yes. Did you talk to anybody else about that?
And Attorney Maloney was on the phone as well.
Did you talk to anybody outside Attorney Maloney or Attorney Riordan?
No.
When did this conversation take place?
This morning,
Okay, at what time?
I want to say, I can't tell for sure.
Okay.
Between 7 or 8, something along those lines, I can't remember.
And when did you text Jennifer Mims Howell?
Probably around 7 before that.
Okay, but this morning, right?
Correct.
Did anybody contact you last night?
No.
No, okay. Did you go to law school?
Yes.
Where'd you go to law school?
University of Wisconsin.
Are you currently a practicing attorney?
No, I'm not practicing.
Okay, but you have a law degree, correct? Okay. And you know what hearsay is, right?
Again, Judge, I think the part of the issues involved is continuation.
Cross-examination is open in the state, Judge.
This is not cross-examination. We're trying to establish that your client is out of the country, which you indicated he is. He's in Colombia, you indicated. You indicated he's out beginning of the 23rd. The only thing we need to establish is whether he was going to return for this hearing, which we don't believe he was, because his vacation was scheduled through April 3rd, 2023.
And I guess before I guess you can answer the question. Do you know what hearsay evidence is? Yes.
Okay. And did Dr. Garcia, did you discuss Dr. Garcia Joven's travel plans with him at any time?
No.
Do you know if Jennifer Mintz Howell discussed Dr. Garcia Joven's travel plans with him at any time?
I don't.
No. And you don't know who Dr. Jennifer Mintz Howell discussed, allegedly discussed Dr. Garcia Joven's travel plans with, correct? No. Okay. So, and you don't know whether Dr. Garcia Joven was planning on appearing here today or not, do you? No. Okay. And did you tell that to Mr. Riordan at any time?
I'm not going to talk about what I was going to tell.
Right, yeah, we don't need to get into their conversation.
Okay, when did you know that you hadn't talked to, you didn't know whether or not Dr. Garcia Joven was returning to, from Colombia?
Can you repeat the question?
At what time did you know that information, that Dr. Garcia, that you do not know whether or not Dr. Garcia Joven is returning from Colombia to be here today?
When did I not know?
No, when did you know that you didn't know that?
That's a confusing question.
I'm okay with that. You
I
don't know?
understand. I don't understand.
Okay.
I'm sorry, I'm just going to object here, obviously, this is a very confusing question. But I think what we can do here to shortcut this is have attorney prosecute the flight information from Dr. Garcia Joven to confirm when he was planning on returning. If you had a ticket before, you can certainly produce that.
Well, and I was going to ask you as well, do you have any records that you can show from MPS application showing when the vacation date was starting and ending?
I don't have anything with me. I could go back to the office. There would have been a vacation slip for Dr. Garcia Joven that he would have submitted, so I should be able to produce it. But this is very last minute, and I can do that.
And you said you could get us more information about from Dr. Garcia Joven about
I have a document that says that he tested for positive for COVID. That's what I have.
Okay,
Are you asking for that document?
I am, but I think Attorney Riordan mentioned a good point. Would you be able to talk to Dr. Garcia Joven and show some proof as to what he was planning on returning?
We're not doing anything like that. Dr. Garcia Joven is ill, and if they want to cross-examine him, they can have that opportunity, but he is not available to testify here.
And you're refusing to get that information from him?
I have not in communication with him, and I have not asked him for his travel plans, no.
Can you do that?
Can I do that?
Yes. If I tell you to do that, if I tell you that we'll take a break, even if it means adjourning, coming back tomorrow, if
Okay.
it's going to take parties that long to get the information, if I get something from you showing what you have on your records from MPS about the dates that Dr. Garcia Joven had requested vacations, and then something from you, the COVID test, as well as something showing his flight plans, I'll make a determination then whether we should continue the hearing until sometime that Dr. Garcia Joven is available to testify, and then the respondent can put their witnesses on.
Okay. All right, are we done then?
I think so.
All right.
Produce that by this afternoon, you want to continue on this afternoon.
I think you said you won't have that information from,
I have no idea if or when I'll get that information. As far as I understand, he is sick with COVID.
right.
Right. So, we'll see what happens.
Okay.
Are we done?
I think we're done.
All right, great. Thank you very much.
So then tomorrow, I'm assuming there's no hearing?
We'll see what happens.
Well, I want to know.
Well,
I'm
I'm not able to tell you something that I don't know.
When will you let us know?
When I have that information.
Okay, I need to know by the end of the day today, because I'm not going to show up tomorrow and go through this again.
Okay. What does that mean? What do you need to know by the end of the day today?
First of all, if he's able to testify tomorrow, we can do it virtually.
Okay.
Secondly, I want to get the information from him as to his COVID test, as well as his flight plans. Because I need to know, I can't keep continuing this hearing without knowing if he had any intention of appearing.
No, what you're doing is discovering bad faith on behalf of the employer. That's what you're doing, Judge, and you know that's what you're doing.
Actually, I'm not. I'm trying to give you an opportunity to present evidence.
We don't need to they have not put on anything that would substantiate bad faith. So instead, in absence of that, you're now fishing for bad faith.
I'm not fishing for anything.
I think we all know that that's incorrect, Judge. We're on the record here, the tape is going.
We're not on the record.
Can you go back on the record, please? Because I need to get this on the record.
We're off then.
Yeah, I'm sorry. I'm sorry.
That's totally okay.
We might be here for a little bit.
Can you let me know where we ended? Like, what was the last thing that was said on the record? Thank
You said you don't have that information. I can only get everyone on that information as far as I understand is COVID, right? So we'll see what happens. Are we done? Yes, great. Thank you very much.
All right, so I just want to be clear, I would like by the end of the day today, the information from you about Dr. Garcia Joven's flight plans as well as his COVID diagnosis.
Right, and I want to make clear that